Hello there. Welcome to another episode of Morning Latte by National Educators Law Institute. My name is Cynthia Beekler, and I'm with Beekler and Associates, and my beloved partner will be telling you all about some interesting things today, including the most important one we're dealing with on this issue is Senate Bill 10, which deals with the Ten Commandments. That has been codified under the Texas Education Code 1.0041, and it talks about the Ten Commandments in public schools. And so we're going to go over what the statute actually says and the implications regarding that, including the fact that there is a similar type of case that came out that addresses this type of issue. So Bill, could you just share with us what the statute says?
Yeah, let's talk religion a little bit. So the legislature just finished their business not too long ago, and Governor Abbott signed most of the education-related bills into law. And this was one of them. The one we're going to discuss today deals with the display of the Ten Commandments in elementary and secondary classrooms throughout the state of Texas. So what I want to do at first, let's just go through what the requirements of the statute what the statute requires as far as the posting of the Ten Commandments. And then we'll get into some of the legal implications that we might have with this. As Cynthia mentioned, there's a Fifth Circuit case that just came out within the last couple of weeks dealing with a very similar law that was implemented in Louisiana. And the court struck down their requirement for the Ten Commandments. So we'll delve into that in a minute. But let's talk about the statute at first. So as Cynthia said, it's Senate Bill 10. It's an addition to the Texas Education Code. It's not an amendment. It's right at the beginning of the code. And basically what the statute states is that every elementary and secondary classroom, not just campus, classroom in the state of Texas, must display a copy of the Ten Commandments. And the section C of the statute outlines the specific language of the Ten Commandments. And if you look at it historically, I felt, Cynthia and I go way back, so we used to watch the Ten Commandments with Charlton Heston and all that, if you've seen that, but it's
a fine movie.
It is a fine movie. We watch it every springtime. But that movie has a version of the Ten Commandments, which is similar language that's in the statute, and essentially it's a Protestant version of the Ten Commandments. So different Christian faiths have different versions of the Ten Commandments. So what the legislature has put down on paper here is really more of the Protestant version, and that'll make sense in a minute as we go through some of the litigation that we have on this. So it says that every elementary and secondary classroom must have a copy of the Ten Commandments. They're very specific. It's 16 by 20. It must be displayed where a person of average sight can see it. So that rules both of us out. My site disappeared.
It has to be a very large font.
Yes, my site disappeared a very long time ago. But what it is, as far as the requirement is concerned, is interesting. So a campus isn't required to spend public money on these displays. However, the school district can. The legislature has stated that the school district can use public funds to buy these posters, essentially, of the Ten Commandments. What the statute does say is that if there is a private donation of these posters for each classroom in a campus, you shall display it. And I think that's probably the way it would play out, is that it might be private donations that supply these posters. So I think that's what we'll be looking at. So, but the language is interesting because it states that, again, the school district they may use public funds, but if we have a private donation, we must hang them in the classroom. So that's kind of an interesting thing. Another interesting component that's a little different than we see on most of the education provisions is that the Attorney General is given the command to defend any public school district that's challenged under this law.
I guess that's the 11th commandment.
Yeah, oh, very good, very good. Yes, the 11th commandment, Attorney
The
General
attorney
Paxton, you shall defend every school district. So it's not just defending the school district, it's paying for any damages that occur, any attorney's fees, any settlements that occur. So the good news for public school districts, and I know the school boards and the superintendents want to hear this out there, is if you are challenged on this thing, we notify the attorney general, and the attorney general will take over the litigation on that.
So you don't have to pay for your own legal fees, what this statute demanded that you do.
Yes, very good. And so this is going to go into effect for this coming school year, September 1st. So it would be for the 2025-2026 school year. So that's kind of a summary of the statute.
Now, you indicated that there is a Fifth Circuit decision from Mississippi, correct? Or Louisiana.
Louisiana, the
hey,
fine state of Louisiana, I know.
Louisiana.
East of Texas, so it's one of those states east of Texas.
It's not Texas. It doesn't count the same. But in terms of the Fifth Circuit, as we know, it includes Texas and includes Mississippi and Louisiana. And the reason, again, in Fifth Circuit, when we talk about that, that's a court of appeals. It's a federal court of appeals. Why does a case from Louisiana or Mississippi, why does a case regarding them, matter to us? It matters because the Fifth Circuit, we're governed by it. So whatever decisions they make, we've got to follow them. There are obviously other circuits like the Eighth Circuit, we don't have to follow, it's suggested, but we must follow the Fifth Circuit. And so with that being said, can you please just describe what that decision says? You said that was recently found?
Yeah, that was June 20th of 2025. So all this, the passing of the Texas law and the Fifth Circuit's determination in this Louisiana case, they're all kind of happening within about a week of each other. So let me do a little bit of background on what we're talking about here and why it's in the courts in the first place. Obviously, 10 Commandments, it's a religious issue. So it's a First Amendment issue, which applies to all of us in the public schools anywhere in this country. And there's two components of the First Amendment with religion that I think are important as far as the litigation is going to be concerned in this. The first one is called the Establishment Clause, which means the government shall not establish a religion. That's your typical violation of church and state or church and state separation, right? And then you have the free exercise component of the First Amendment, which means that each of us as individuals have the right to practice whatever religion we want without the state telling us what we can and cannot do in that regard. So when we talk about litigation under the First Amendment, there's two different paths that you can take: Establishment Clause and Free Exercise Clause. So there's a case from 1980, which is a long time ago now. It doesn't seem that long ago to me, but there's a case from 1980. It's called Stone versus Graham, and that's the case that really the Fifth Circuit was looking at.
That's the impetus.
Yeah, that's kind of the impetus to this. And it was a case from Kentucky where it was a similar situation where some private donations were made to schools in the state of Kentucky. And it was the 10 Commandments, the posters, just like we have at issue here. And that went to the U.S. Supreme Court. And the Supreme Court struck that down. They said you cannot have the 10 Commandments in the classroom. Okay, so that's kind of what we've been looking at. That case has been around for what,
45 years.
45 years.
45 years.
Okay.
It's a pretty long precedent.
And then what happened fairly recently is, and a lot of you are familiar with it, it's the coach kneeling down and praying after a football game. That's Kennedy versus Bremerton School District. And in that one, I'm not going to get into too much detail because it could get kind of boring, but it dealt with a change in the test that's used to determine whether there's a violation of the First Amendment. We'll kind of leave it at that. So that's why some of these legislatures are moving in this direction, because the Supreme Court has been a little more sympathetic towards religious rights in their last 5 or 6 sessions. It's a conservative court now, and they tend to be a little more sympathetic to religious arguments. So that's kind of the background of this thing. So what happened in this Louisiana case, it's a statute that's very similar to what was just passed in Texas. They have very explicit language as to the 10 commandments, and the verbiage is very similar to what we have in Texas now.
So was it seeking to have the 10 commandments in school?
Yes.
Okay,
Yeah.
so it was a similar statute.
Very similar. Yeah. And it mandated it. And the litigation started with a group of other Christian faiths. Like there were some Catholics in there. There were some atheists in there. And then, any faith, could be Muslim, could be Hindu, could be Buddhism, challenging this law, saying, first of all, you're forcing us through state action to view these 10 commandments every day in a classroom. And there's disputes even among the Christian faiths on the language. And that's why what the legislature did here in the Texas situation is important, because they have very specific language, and it says they're mandating that's what has to be said. So in Louisiana District Court granted the injunction. In other words, they ruled for the plaintiffs initially, and there were a lot of plaintiffs and a lot of defendants in this thing, but they ruled for the plaintiffs and said that the Louisiana statute violated the First Amendment of the Constitution. They appealed it to the Fifth Circuit, and as Cynthia said, the Fifth Circuit applies to us. And it went to a panel of 3 judges there, and they unanimously found that the district court was right, affirmed the injunction, said that it's facially unconstitutional, the statute. So now that just happened June 20th. There are some procedural components that may come about. We've talked about en banc determinations before, and what that essentially means is that a full review by the court will take place. So when these decisions are heard, they're in front of 3 different judges. An en banc decision, I think it's 9. So they may seek that review to try to reverse the decision of the Fifth Circuit in the initial panel, but we got to see what's going to happen with that. So the way these things, the way they can pass constitutional muster, that's some good legal language there, is that it has the statute has to have a secular purpose. So in other situations, for example, when Congress opens their sessions, they have a religious prayer done at the beginning. And that had been challenged before, but you look at a historical perspective, and if it has been done historically, the court is more likely to find that it doesn't violate the First Amendment. So in this case, I think it's Rourke, R-O-A-K-E was the name of the initial plaintiff in this Fifth Circuit case. What they were trying to argue, what the state was trying to argue in this Louisiana case, is that there was a secular purpose for displaying the 10 commandments within the classroom. That the 10 commandments are really just kind of a moral base that we've accepted in society, and that some of our criminal and civil laws are based on the 10 commandments. Obviously, thou shalt not kill, murder. Always a goal. Yeah, always a goal. So, and that is true. There is a component of that, but the Fifth Circuit just wasn't having it. They said there wasn't enough of a history there, and you look at these situations, and there was also a case in Texas where the 10 commandments are displayed on the Capitol lawn, and that actually has passed constitutional muster. In other words, it's been found constitutional. But the difference between the 10 commandments being on the lawn of the Capitol and being in an elementary classroom is a captive audience versus a non-captive audience. And I think in this litigation, that's always critical. So we can choose to go on the Capitol grounds. We can walk by the 10 commandments and not look at it. But if our kids are going to a public school in a classroom, anywhere pre-K through 12th grade, and they walk in and they're displayed visibly, even though Cynthia and I wouldn't be able to see them with our eyesight, they are in the.
Speak for yourself. I think I can
see. They are in the classroom, so you're a captive audience, and the courts kind of look at that, and the Fifth Circuit certainly did in the Louisiana situation. So that's kind of where we are on that litigation. Even this past week, we're in June, so the legislature just ended and Governor Abbott signed that into law. There's already litigation in North Texas on this. They sued a school district. They sued the education agency and some other defendants. So obviously the watchdog groups are out there and we're going to have this litigation rolling now. So it's June. We said it goes into effect September 1st. So I think what we need to be looking at is what do we do? You know, we've already had these questions. So, I mean, we just kind of give general statements here and we kind of look at the statute and give our comments on it. But I think, you know, when a statute goes into effect and the education code is binding on all Texas school districts, we have to follow the law. We have to follow what the law says.
We do. But what's interesting is there's already litigation, which is seeking probably to enjoin that, them actually enforcing it and finding it unconstitutional. So the good news is this: if you display it, AG's got to represent you, and any fees, costs, and attorney's fees are going to be absorbed by the state. So keeping that in mind, that's a rare situation, as you all know. And clearly it was anticipated, I believe, in the way that it's drafted, that there would be litigation. So they've prepared for the litigation, and at least from the state standpoint, they're willing to take that on. And that's where we are at this point. Obviously, there's going to be another episode of Morning Latte that will deal with the litigation that is already in place that's going to be dealing with this statute. So fascinating things. Always, you know, legislature meets, it's always a sorting time afterwards. We all have to figure out what they've said for us to do and sort through it and figure it out. Like I said, at this point, if you follow it, then obviously anybody challenges you, you will not be responsible for any of the liability that may be attached to actually following the law that they mandated that you follow.
Exactly. And I think you do. I think you follow the law now until you hear differently, because it's been signed into law. It's they use the words must and shall, which means we have to do it. The only thing we don't have to do that's may is you don't have to use public funds, but the board can choose to use public funds too. So this, you know, every school district can be a little different on what they choose to do there. But yeah, I think as we sit here today, I think you follow the law until you hear differently. If you follow the law and you get challenged on that, the provision states contact the AG, and the AG is going to defend you on that. So we'll see where it ends up. And I agree with Cynthia. We'll have another edition of Morning Latte at some point, because this is not going to die.
It's not going away. And again, we've got 2 months before September 1st, so I can assure you, lots of activity may be occurring on this. That being said, thank you for joining us, and we will have a link for this particular statute for you to be able to access on
nellylaw.net. There you go. You'll be able to access the statute there. And we'll go from there. As Cynthia said, we're going to go over some of these other legislative changes that came up. It was a pretty active session, so we've got a lot to talk about.
Lots of fun things, so many good new things for the episodes that we're going to have going forward. Thanks for joining us.
Thank you for joining us. We'll see you next time. I like the